Welcome to Tax Practice Pro's September 2019 Representation Update. This program was previously recorded on September 6, 2019. No continuing education credit is available for this rebroadcast. Information discussed in the program was current as of the reporting date. The program is sponsored in part by our friends at Tax Help Software. Tax Help Software automates the process of downloading IRS transcripts and analyzing changes to taxpayer accounts. Detect IRS audits up to 6 months early through the use of this software. Register today and save 10% with code MD1099. This program is also sponsored in part by Call and Queue. Cut your IRS hold time to 3 minutes or less with the use of this innovative software product. Use our trial link to get 200 minutes for $19.97. You will never want to call the IRS directly again. This program is presented by Tax Practice Pro, a continuing education provider for enrolled agents, CPAs, and other tax professionals. Check out our list of upcoming live and webinar programs at www.taxpracticepro.com. You can download the court cases and other material referenced in this presentation at this link. The link also appears in the comments section underneath the video. Good afternoon, it's 3 p.m. and welcome to Tax Update or 2019 Representation Update. John Sheeley here in New York with Marc Dombrowski also in New York, but at the other end, so 6 hours away. I can fly to Orlando. I can drive to the Newark airport and fly to Orlando quicker than I can come to your office.
I can go to Detroit faster than I can go to your office. What does that matter?
Why would you?
$1.98 will get you coffee, eh?
I guess so.
We're already imputing knowledge.
There you go. So today's discussion is going to center on a couple of recent tax court cases that we think are relevant to your practice, along with some Internal Revenue Manual developments. You earn 1 CE for this class for NASBA and for IRS purposes. If any of you from California are on, you can get CTEC credit. I do need you to stay on for 50 minutes. I do need you to answer 3 of the 4 polling questions. I trust that you'll be on for the full time, but the regulators ask us that we ask you the occasional question to test for your presence on the call. You don't have to get the question right, but you do just need to answer. There are 4 handouts available in the handout section. One of them is the agenda, the program number, and all that relevant housekeeping stuff. And then there's 3 other pieces of information, the 2 tax court memos we're going to discuss, along with the relevant IRM update. The IRM update is like 14 pages. Did you see that?
Yeah, I did see it.
Oh, you read it before we discussed it. Got it. Okay. If you have any questions, by all means, pop it into the question and answer
I have many
box.
questions.
Yeah. So, Marc, let's open up with, since I've introduced you, let's talk about some of the IRM changes that are out there.
You're specifically talking about the transcripts as far as
Well, that's the big thing, right, is the change to transcripts. And more importantly, some of those questions that our friends at the IRS are asking us when we call practitioner priority service.
Well, so that's been since October of last year. So in the grand scheme of things, it's under a year. So in some worlds, that's a newer development. John, actually, you and I discussed about, you probably do remember it because you have an insane memory, about in February of this year, there was one of a tax client called me. She worked for a law office and said that there's a new thing about head of household, a new change in the law, head of household. You ended up, because of your confusion, figuring out that she was talking about something that happened in 2012. And we were both duly impressed on how the legal community has kept abreast of law changes. And she was talking about the head of household, the head of household changes that were, again, 6 years ago, 7 years ago. So I don't feel too bad saying, well, a new change just for everybody. Generally, people who have who are talking about transcripts a lot have already dealt with what I'm about to say. But in brief, it's simply looking at telling your social security number, date of birth, DNA, firstborn, all that other stuff, preference, brunettes, bronze.
When you say yours, you mean you, the
Practitioner.
practitioner.
So obviously they're going to ask, it is ironic that they don't ask the taxpayer's date of birth, but they're asking our date of birth. But we do see, and I like to, I almost like to see when I'm talking to an ACS rep or a practitioner priority service rep, I like a complete, I don't even hesitate. When they say, what's your date of birth? I just boom it out. I don't go, why are you asking me that, or any of that stuff. I think it's representative of my professionalism and the fact that I've done this before to just roll right into that date of birth. I say it as loud as I can in the office, along with my social security number, middle initial, and my dog's first name, so that everybody knows all of my pins to get into the safes here at the house.
Well, I mean, all right. So a couple of points that I wanted to make sure we brought up here. One of the things that the callers are supposed to be the PPS assister, as they call them, right? The PPS assister is supposed to be asking you the purpose of the transcript. And why are they asking the purpose, Mark?
So they know where to put it?
Maybe, right? Because well, generally speaking, transcripts are now redacted.
Correct.
And they are annoying to work with. So if you haven't worked with this, you'll get like the first 3 characters of a name. So John Sheeley would be JOHSHE.
Right, with a space.
Addresses include the first couple of digits of the number and like the first letter. So my office
it's the first 6 characters of any address. So
the first 6 characters.
Yes. So if it's
93 Brookside, you get 93 space bro.
Yes, correct. Correct. It's
Also,
like if it's 131st Street, and then so you're not getting
some of these addresses, like in Queens, that would be 131-07 Corona Boulevard, would just be 131-07. That's 6 characters.
And Milwaukee has a lot of they like your address is almost like a grid work. It's exactly what your house is, and it's I imagine again you're going to get 6 numbers and that's it.
Oh my gosh. So what can we as a practitioner do?
Revolt.
So that, well, revolt, yeah. They're not faxing anymore. So they're going to be looking to put these things into your secure object repository in e-services.
Yes.
Which we also call the
SOL.
The mailbox.
Correct. SOR. SOR.
So what's interesting about that is they don't quite pull it out of you yet, but one of the reasons they're asking you about why you do the return is if you remind them that you are preparing an original or an amended return, they will send you an unmasked wage and income transcript.
Correct. Why you're doing it is for return prep is an interesting thing. You've got to ask for, just to be sure, not only tell them why you're asking for these things, but also talk to them about requesting an actual unredacted transcript, income transcript.
Correct. Wage and income, yeah. And they will send it.
And just to clarify, because Jeff Johnston properly said, it's for names, it's the first 4 characters of the first name and last name, but then for address, it's 6. Just to differentiate there. It's just a small difference there. And that's what we said, but I want to make sure.
Got it. So anyway, you almost get them instantaneously now. So as part of this, the other thing that they're asking is, what is your mailbox ID number? Your mailbox, which is usually your login. I think it's always your login.
Correct. And in that download that you've given them, the handouts, it is important. And when you read through those pages, and I'll be honest, there's a lot of that stuff that you breeze through because it is the IRM. It is telling an employee for their day-to-day work how to do their job to the point, to the field, what to enter in, whether to use capitals, whether to not use capitals. I was reading that just a little while ago. And it is a situation where they make it very clear to clearly have the document locator number as well as the social security number accurate so that you know what you're doing. And you have to ask, and this is definitely new since July 22nd, that's the IRM update here, that they're asking for, as John just mentioned, they're asking for your e-services ID. Actually, I did not put my D&D on. There you go.
Well, what's interesting is an individual who we nameless, a CPA we both know, uses a name that she's slightly embarrassed with.
Jennifer Lopez?
No.
Okay.
Because who knew you were ever going to need to repeat these things out loud?
Okay.
So that can be a bit of a problem.
Oh, you're saying her e-services ID, much like some clients' very embarrassing email address. I had one today that was just hilarious, and I kept reading it, and I'm like, I wondered, that's not a derivation of the guy's name. What the heck was he thinking when it was just like pornographic what the guy had?
Well, it's a great conversation piece, I guess. I mean, my birthday's on Christmas, and that usually starts a conversation when I'm speaking to a PPS's sister. But the interesting point here is that you've got to say it, and now the IRM, to your point, Mark, if you read this IRM update, it reminds them to repeat it back and ask us to repeat it a second time.
Which I never had. And case in point, understand this, revenue officers and revenue agents do not ask these things. So these IRM updates are for IDRS accessing employees, practitioner priority line, ACS customer service. It does not have anything to do with revenue officers or revenue agents.
So any other IRS contact you have too, it could be fraudulent if they're asking you for the e-services username.
Yeah, here's a good question. Revenue officers aren't doing it. I didn't research whether or not revenue officers should be doing it or could be doing it. So the question begs is, if I have a revenue officer in Buffalo, this posted duty, a lot of the revenue officers are by the books. They're highly intelligent, highly skilled. I've had the honor of being educated in the representation field in upstate New York because of the quality, if you will, the enemy, if you will, on the other side of the board is a quality person. And there are some that are very by the book. There could be a revenue officer. If there's a revenue officer I've dealt with for 20 years, ask me my social security number and date of birth, at that millisecond, what do? I'm going to just tell them that. If they say, oh, this is the first time we're on this case and I want to know your date of birth and social security number, I would probably pause for a millisecond, but then probably just tell them. I mean, they certainly could look that stuff up if it's part of their identification process. My problem with it is they know darn well who I am.
Well, they have to do it. Some of the call centers, you're allowed, IRM allows 5 customer requests, right? 5 cases.
When you call practitioner priority line, 5 cases.
Right. Now, if you get Philadelphia, they will make you
every time
verify yourself on every call. If you get Holtzville, not so much.
Correct. And I agree. Now, I'm not sometimes.
Don't get me wrong. They do it once at the beginning of the call. And then what they will typically say when I move on to the next client is, okay, you've previously authenticated yourself to me. And the reason I think that gets in there is have you heard Commissioner Reddick this year speak?
In the front row. I could see the spittle coming out of his mouth. Yes.
I believe starting with Frank Agostino's enforcement update, I think I've heard the commissioner 5 times now, including twice.
I love the guy.
Twice in 1 week when I was in Las Vegas.
Was it the same speech?
Yes, it's almost the exact same content because he talks about his experience double jacking.
Right.
Now that sounds like something out of a science fiction movie, but double jacking is when an IRS employee, supervisor typically, is plugged in and monitoring the calls of individuals. So I think when they do some of these things, such as say, now you've previously authenticated yourself to me, and they move on to the next case, it's because if someone is double jacking and comes in mid-call, it doesn't look like they have failed to authenticate. They probably still have a problem, but they're good.
Right. I mean, obviously you're not going to risk being written up if you're an ACS rep and it's your first 6 months of whatever. And the rumor on the floor is the boss is going to be listening in on some of these phone calls, the supervisor. You do your due diligence reverse due diligence for your own job. And you have to respect that. I'm not the kind of rep, it just depends on time, whether or not I ask them, hey, where am I calling? Is this hello, Philadelphia calling? I don't always know where I'm calling. I used to do that a lot previously. And just depending on timing, I will find out, am I calling Holtzville? You can tell by the accents sometimes. But
The best thing is when you find out they're in Buffalo and you ask them if they're in the shopping center, and they say, "How do you know about the shopping center?"
yes, when they're calling from the Big N at the Como Mall, you know it's probably going to be one of Marc Dombrowski's ex-girlfriends.
Well, no, you actually get a good laugh when you tell them, "Yeah, I know where you are." So what the IRM reminds you here, the update, if providing an unmasked wage and income transcript, it can only be mailed to the taxpayer's address of record or uploaded into our secure object repository. They won't mail it to us. They certainly no longer fax. Now, a couple of comments coming in have been, well, I'm using insert name of program here that gives me unmasked transcripts. Something tells me that they have, because this has come up before, and I know Bob Currett and EA knows about it. And I think my one thought is that since we're getting it electronically, they know we're getting it electronically. I think that they feel it's the same thing as a secure transmission to the practitioner, and that's why we're getting them unmasked. So I agree, if you're using Pitbull, Canopy, or Tax Help software, I have reports. I'm a Tax Help user. I know Mark is a Tax Help user, our friend Roger Nemeth, also an EA, right? Privately owned company with no outside money, and he's an EA, so we like him. I was going to say something, and now I forgot. Oh, well. Anyway, I know that they're all
transcripts.
Yeah, but the one other thing that's coming up, and this has been coming up for longer than the masked transcripts, is that they're asking for our social security number and date of birth, us the practitioner. And we had a discussion with someone online in one of the Facebook groups where she had an older client who was not comfortable with a power of attorney, so she made the call with the client in the room and she had to self-authenticate. And of course, here's this guy sitting there hearing your social security number and date of birth, which probably isn't cool. But
I did it with a tax prep client who let's just say there was a mistake made. Yes, we all do make mistakes. The staff made a mistake, and to fix it, it's become this nightmare. I was talking to the staff about it today. There are just some clients that are doomed. They're just doomed. They could be really good people, say their prayers by night and have pure of heart, but every full moon, the IRS loses their estimated payment or didn't process their amended return forever, or just the IRS lost their amended return, the amended return I did, which to correct an error made in this office. And so they're sitting here and they're angry. They're very angry. In fact, the wife had come in and said, "You're lucky my husband's not here." And I said, "Okay, let's call him up. Let's get him in the parking lot. Come on. What year is it? Are you going to go drag me out in the parking lot?" Well, the next time the husband did come, and I wasn't dragged out in the parking lot. But anyways, so these two people in a and she's already said, "We're not coming back next year. We're not coming back next year." And I had to give the practitioner hotline people my social security number, and with the door closed and just the three of us in the room, social security number and date of birth. Now I could have asked them to leave, I just need to authenticate, but I don't even know what the practitioner hotline person would do. Let's put ourselves in the practitioner and the person that she hears me say, "Oh, Mr. and Mrs. Johnson, can you please leave the room? I need to give them my social." Does she say, "I'm sorry, I need to end the call because they're not here, so I can't authenticate you"? The two different people could have walked in your room. So I just ran with it as a sign of good faith.
They're writing. They don't have a piece of paper. I doubt that they would. You'd have any ID theft there. In reading through this, and then we're going to move on to the cases. But one of the things I found interesting is I'm reading some revised content where they removed the faxing solution, and they talk about ID theft. Now, something like a third of IRS employees touch ID theft at some point. So they're talking in here about, if they call up and they need proof of a non-filing letter and all of that,
and they can't do it because.
But you want to say it? What's the part they remind them not to do?
I don't want to say it because I'm not
victim.
Give them all the information.
right?
Right.
But not to share what with them?
The name and social security number.
Right. Well, the name and address of the person who filed the
Supposedly is on the
fraudulent
phone.
return.
Right.
Yeah.
Right. Oh, right. No, okay. Right. Yeah. Of the thief. Do not reveal the thieves. Be careful. Do
Any
not.
information you have about the thief or the fraudulent return. So you're entitled, before the Taxpayer First Act, the year before, they changed the law that victims are entitled to a copy of that fraudulent return. Of
Mhm.
course, it's redacted. We're not going to tell you what address was used on it because that might give you a clue to what.
Go knock on his door, or go slash his tires, or
Yeah,
in
we
most
we live in.
cases, go knock on the door that's hanging off by a hinge because the house is either abandoned or some. I don't know. I found that a significant number of criminals, like 2% of them are driving a Mercedes, and 98% of them are driving a 1986 Chevy Nova, not the good Novas.
So the two cases we're going to talk about today, interestingly
AMC
enough, and
Hornet.
yeah, well, it was not intentional, but they are both um, pro se. What's pro se? They represented themselves in tax court, and I find this amazing. And if you haven't gone to a calendar call, you really should. You can sit there and see how this works. And
I did. It
the
was
US
awesome. Thank you. Thank you very much.
for guilting you into that. The
Yeah.
U.S. tax court is not a court of equity. It's a court of facts. And what I always find interesting is that the court is not required to do anything other than weigh the facts. And working with Frank Agostino, you've seen how many people show up, usually pro se, with a shoebox of receipts, or like they've got a parking or a speeding ticket with some piece of paper to throw themselves in the mercy of the court. And it never ceases to amaze me how gentle the tax court judges are, judges who aren't elected either, right? Appointed judges. And they essentially will give people additional time to put their stuff together, including people that have ignored a series of 7 notices, provided no proof, responded to nothing other than paying their $80 to go to tax court, and boom. So,
And
but
Judge Vasquez, at least I just saw his name on one of these cases that we have out there, who I love. I've had dinner with him a couple times. Just an amazing, very down to earth, regular. He and his wife, very amazing people. He would come to the NYSSCA
SSCA, yeah.
and conventions back before you were even born, John. I
I
was
don't know
having
about that.
dinner with.
In fact, he came to a few back when I used to go. But yeah, Judge
I
Vasquez,
didn't
it
know
turns
you back then. At least I didn't see you there.
Judge Vasquez, yeah, you did. You introduced me one time, and you went up to your room, took off your suit, and came back in a pair of jeans and t-shirt to introduce me. You did a
I
great
hate
job.
wearing suits. I hate wearing suits. Hate it, hate it, hate it.
Another example of your professionalism. Anyway, you're right. Judge Vasquez has been is a great friend to both enrolled agents, and I believe Don Rosenberg got him to speak at Hostos Community College on something at one point on a panel. So he's a very generous guy, and it turns out he went to a community college his first 2 years of school. So he's a
Mm-hmm.
big guy on education and giving back. So very important. So anyway, coincidentally, both cases are pro se cases. So Danny Love is a case of a guy who felt that he go ahead. It was a collection due process case. And what's collection due process, Mark?
CDP, a collection due process, is where the IRS has issued a final notice, or I'm sorry, notice of intent to levy and your rights to a hearing, giving the taxpayer whatever method it was, a CP90 or a 1058 or an LT11, some of these other various letters that are out there that give the taxpayer the ability to enter into an appeal of the proposed levy action within 30 days of the date of the letter. If you file the form 12153 within those 30 days, you are allowed to get a fully valid collection due process hearing process, and including, if you disagree with the appeals officer, the settlement officer, to go on to tax court, which is what this Mr. Love did. I'm very well versed on this case. If you want me to take it from here, John.
The only thing I'm going to say is the basis of his case was that appeals rejected his offer in compromise. And he said the doctrine of that's not fair.
Correct.
And
discretion, abuse of discretion.
correct, that they should have been nicer to him.
Correct.
So, okay, so then what happened once he got to tax court?
So he filed a CDP, and then he followed it up by filing a 433D, as in David, to ask for a $300 a month installment agreement while his offer was being reviewed. He then filed an offer in compromise. Well, I'm sorry, he filed an offer in compromise. He filed the CDP, he filed an offer in compromise, and then filed a 433D. The appeals officer received the 656 within the time frame, told the taxpayer, listen, I'm going to send this to this centralized offer and compromise unit. That is the procedure currently, is if you file an offer and compromise within a CDP process, that offer will be shipped off to the offer unit for them to do their job, their due diligence, and then that way appeals is not tied up. If the offer unit acknowledges or approves the offer in compromise, then the appeals officer just needs to kiss it at the end of it and get a withdrawal of that process. If the offer is rejected by the centralized offer unit, then it can quickly go back to a settlement officer, that particular settlement officer who's been assigned the case, so that they can instantly review the offer in compromise. So one advantage of doing an offer within a CDP is you don't have to wait the months and months of a regular offer and compromise appeal. In other words, for those of us who do a decent amount of offers, when you file an appeal on an offer and compromise, there's a lag time before the offer case, the appeal is picked up by appeals. In this case, it's I want to say immediate. Within a couple weeks, you get an appeals officer, a settlement officer, talking to you directly about your case. So it is expedited. Sometimes you don't want that to happen, but in the cases where you do want to move it along or you're confident in your case. Well, in this case, the taxpayer did not substantiate all their expenses. They took expenses that were not allowed, tuition, private tuition of a big number specifically. Tuition of $1,162 for private schools per month, $1,162 per month for a private school. Now that's chicken feed to some of us. I mean, what was I was paying,
but that was used in arriving at their collection potential, right?
I was paying $2,700 a month. That's nothing to some of the other people on this call, what they paid for private schools.
Mark, so that deduction was used at doing what? For those that don't do a lot of offers, at arriving at her
disposable income.
Right, whatever was left over at the end of the month, they could go to the IRS. Got it.
Correct. So the IRS was applying the collection financial standards properly in the offer and compromise unit. They came up that was a $39,000 liability for 12, 13, and 14. And whether it's
12 to 16, I thought.
12 to 16. And they made a determination that from assets and from the ability to pay, the person could pay $217,000. So you get this offer back. It's for those of us who do these offers, who do offer and compromises, you get an answer back and it says, thank you for your offer and compromise. We feel that you can pay $217,000. When you submitted this offer, the guy submitted it for $1,500 settlement on a $39,000, let's call it a $40,000 liability. So he had $42,000 in assets, disposal value of assets alone. The appeals officer got the case, and here's where the taxpayer said the appeals officer abused their discretion.
Well, before you say that, his monthly collection potential, what was available for the DI? $1,712.
$1,712. Okay.
Right. Okay.
Equating to
one month of disposable income exceeded his whole offer.
Right. 1 month on a pro se, and again, this taxpayer sending in a CDP, sending in an offer, sending in a 433D, you know that the guy's not all with it. Well, from everything in this case, the settlement officer treated this guy with kid gloves. They actually allowed multiple vehicles. And I think I know, and for those of a lot of people who do collection work, revenue officers and appeals officers, and sometimes even people in ACS, they do look at a bigger picture and say, you know what? If I allow this guy all the cars and all this other stuff and just deny the tuition, which I know I'm solid on, he still is a full pay. So why don't I give a little? Because it's not going to matter. He's still going to be a full pay case. This appeals officer said, listen, they're going to allow multiple vehicles. This appeals officer upped some of the national, the collection financial standards for the guy because there had been a lag, a period of time. He also took some of the guy's expenses and said, no, you're not even taking the standard on these. I'm going to up some of these. The guy still was a full pay case. And then this appeals officer came up with an alternative resolution of $600 a month and said, I'll withdraw the lien if you agree to a direct debit payment plan.
So and actually, she allowed him, this was a 2017 issue. She was allowing him $300 a month in 18, rising to
that's the second. Hold on. That's the second appeals officer that got involved.
Never mind. Got it. All right.
So the first one said $600 a month direct debit. I'll withdraw the lien. He talks a second settlement officer into a sweetheart deal, withdraw the lien, a stepped, that's what they call it, a stepped payment plan of $300 going to $600, going to $700 a month. And even though the Internal Revenue Manual talks about withdrawing a lien sight unseen if it's under $25,000 and setting up a certain parameters for that to be paid off, this appeals officer does that on a $40,000 liability. He's given the guy
her discretion.
Right, correct. In fact, both of these settlement officers' actions, in my professional opinion, is, as you're saying, going above and beyond in their own discretion, allowing a proper resolution. Well, the taxpayer didn't see it that way. Filed a tax court, pro se tax court petition, because he wanted the penalties removed. He wanted the interest removed and the penalties, which all taxpayers ask for. Oh, I want the interest removed and the penalties. And the settlement officer said, well, I have no authority to abate interest. Congress, it's statutory. And you don't qualify for first-time abatement because, lo and behold, you've had failure to pay for 09, 10, and 11. So, no, you don't qualify for first-time abatement. There's no reasonable cause, capital R, capital C, for you to get into penalty abatement. Outside of that, the taxpayer also wanted them to remove additional tax assessments, but provided no basis for the reasoning behind those.
You mean the 6662A? Probably the additions, the statutory additions, you mean?
No, this was some sort of additional, like a CP 2000 had come out. There were additions to tax. These weren't just failure to file, failure to pay.
Additional tax or additions to tax?
So it was an additional tax assessment is what it said in the court.
Got it.
So the moral of the story is, when you file these tax court petitions and in appeals, it is important for the practitioner to know that an appeals officer or settlement officer is looking at, did the IRS violate a taxpayer's right or a procedure? I've had plenty of settlement officers who agreed with my position, but said the way the IRS denied you or gave you an alternative may not be palatable to you. And I agree with you that I wouldn't have done it this way when I was an RO or I was an ACS rep, but they didn't abuse your client's rights. The tax court has to also look at, did the appeals officer abuse his or her discretion in making a determination in denying the offer in compromise and denying the penalty abatement? And the court held that there was no abuse of discretion by the settlement officer. So
on page 10 of the case, our review of the record reveals that SO1, Settlement Officer 1, conducted a thorough review of the petitioner's account, determined the liabilities in question were properly assessed, and verified all the other requirements of applicable law and administrative procedure were followed. So,
yay.
So I want to get on to Richard's, Mark. I mean, what's the big takeaway here, aside from the fact that maybe you shouldn't do these things on your own, you should bring in a professional?
Well, it's the unrealistic expectations, and it's something that I push through fellow practitioners from a practice standpoint. Is the number one conflict between myself and any representation client, or even any client at all, is they come in and they, whether it's, hey, I'm really going to get a refund this year, and you say, I don't know if you're going to get a refund this year, and well, Trump screwed up everything. Well, I don't know if you're going to get a refund. Maybe you're going to get a bigger refund than you got last year. Am I going to be able to do an offer in compromise? I can't pay my bills. I don't know if you can do an offer in compromise. They hear when they left that office, Mark said we could do an offer in compromise. Unrealistic expectations of the taxpayer is the big takeaway there, in that they felt that the offer in compromise, obviously, they felt they didn't know the rules. So whether you're a practitioner or a taxpayer doing this pro se, the offer in compromise pro se, you have to know the rules of the procedure that you're getting into, whether it's a CDP procedure, an offer in compromise procedure.
And whether you actually didn't get what you were entitled to get, I guess, right? What am I? Yeah. Okay, so Richards, again, another CDP case, another pro se case, but as we've said, from our good friend Judge Vasquez. So go ahead. Why don't you set the door for us?
So this is a question that I get from taxpayers and practitioners alike, obviously much more often with taxpayers. I want the thanks, John. I want the lien removed because it is inhibiting. It's bad on my credit report. I got a call yesterday of a guy who said he went for a loan and it wasn't on his, the liens weren't on his credit report, but it was on his public record search, which is what the bank did. The bank didn't do the bank did a credit record search. The bank also did a public record search, and that's where they came up with the lien.
So in other words, the lien was filed in the county and the credit bureau hadn't picked it up yet.
No, the credit bureaus, as of the summer of last year, I'm sure Clarice will correct me if I'm wrong, but as of the summer of last year, the credit reporting agencies got sick and tired of being brought in front of the bench for not having accurate credit reports. So Congress requires any credit reporting agency to be able to vouch for the information in their system.
Got it.
Since a federal tax lien neither has the taxpayer's social security number nor their date of birth on it, it is the credit reporting agencies they talked to each other and said, let's just do this. We're not going to report liens any longer because the liens can't be verified, because we're getting our butts handed to us constantly by consumer complaints. Let's make everybody happy, and except for the banks and the lending institutions. So you now have credit reports which don't have it. Honestly, I don't know if I had actually, I do know. I heard that what the credit reporting agencies did is they went into all the credit reports and pulled out even federal tax liens that had been filed in 2008, 2010, 2015, because they couldn't be verified. Because there was one point where we didn't know when they came out with this announcement whether it was from now on that they weren't going to be reporting them or whatever. And the credit reporting agency said, well, bad info is still bad info. We're going to get rid of it out of our credit reporting things. So this question, this Richards case, comes up all the time. I want this lien released, withdrawn, because it is hurting my credit. The appeals officer denied that request, and the tax court affirmed it. Sustained.
Just a little piece in the middle. So these folks, if you will, went through the process.
A CDP, right?
Yeah, notice federal tax lien is filed. They go to a CDP. In the CDP, they said, you got to take away the tax lien. It's ruining my credit. It's not fair. My favorite doctrine, the doctrine of it's not fair. So it becomes an abuse of discretion case. It goes to tax court. and all facts were stipulated. Everybody agreed that everything that transpired was correct, except
it would not facilitate the lien. The releasing the lien would not facilitate the collection of the tax, and it would not be in the best interests of the U.S. government. Which,
right.
again, the argument is out there that it's inherently it would help the IRS collect. Well, it's a glass half full, glass half empty. Is it inherently that if I don't have a lien, I'm able to happily rent apartments, get the best mortgage rate? If I'm losing a point of interest over 30 years because there's a federal tax lien against me, isn't that inherently hurting my ability to pay the government back?
Now add into this an interesting twist. They had an installment agreement. They made their payments for 2 years, and then in 2016 they defaulted. They stopped paying. Someone got the case marked currently not collectible. Then they got the notice of federal tax lien.
Right. Because of and one of the many times when you get a case deemed a hardship, a CNC currently not collectible, the only way you know that it actually stuck and that you got the case deemed uncollectible is a notice of federal tax lien being filed. In other words, here you are, the practitioner, you think the guy's a hardship, you go through a case, you go through the financial statement on ACS, and they say, okay, if my supervisor agrees, you'll be notified. Well, that's a good 50-50 stipulation there that you're going to get a letter. In my professional opinion, my experience, about 50% of the time, I never hear anything. 50% of the time, I get the get out of jail free card, the CNC letter, which I obviously prefer because the clients, you're going to hold it. Hey, here's what I did for my retainer. This is what we did. At least, it's obviously it's kicking the can down the road. It's not an actual resolution, but it's at least it could. If there's only 2 years left in the statute, maybe it is the resolution that ends the case.
I learned one interesting thing from you. I've had situations where, in a case like this, we get it marked CNC, and the PPS sister or ACS, whoever I'm talking to, says, "Oh, there's no federal tax lien filed. I guess I better take care of that." And you once told me that what?
Wait, say that again. As soon as they collected a CNC, they're going to file the federal tax lien. It's standard SOP.
Correct. Okay.
IRM is to file that lien right away. Right. Because as I was taught by one of the members on the phone call here, the lien works while the RO sleeps is one of the cliches of the IRS. Other than don't seize if it eats or floats. And it's this removing the lien. I think I've got one out there right now on a withdrawal lien that's simply no. I got an answer. I actually got an answer. Financial planner guy local to me, and just when you talk about the other taxpayer in that first case, this is the kind of guy he owed, hundreds of thousands of dollars. We got an offering compromise accepted in 2015. He still, to this day, has not made any of his estimated payments correctly. I just got the IRS on 2016 not to default. His offer is still valid right now. I've been juggling. I've been playing every card, using every system, pulling all the tricks out of my hat, and the guy just for 2016 and 17 just full paid those two, and I was able to keep his offering compromise valid. He's still why is 2018 on extension? Because he didn't make estimated payments, and he doesn't have the money. It's due in 45 days, less than 45 days. He's got to come up with that money. What does this guy want from me? What is he demanding after being a client for 6-7 years? Okay, of hearing me banter to him about, obviously I'm not a good representative if I can't get this guy in the straight and narrow. He asks me for penalty, insists on penalty abatement on 16 and 17. On what basis? Certainly not first time abatement. He has no reasonable cause. Nobody died. He didn't get, horrible diseases or anything like that. There's no reasonable cause. There's no first time abatement. And then he wants the lien that they filed on 16 and 17. Again, a miracle that I was able to keep that offering compromise retained. He wants the lien withdrawn. because he's in financial planning, and it's going to cause him problems. Of course, it's going to cause him problems. Maybe if you're a little more have your eyes on the ball, eyes on the prize, you would have understood it. So,
well, people end up in these problems all the time. So interestingly, though, they go on and basically the taxpayer was concerned he's not going to be able to buy a car. All right, that's the jux to this case. And of course, if you're currently not collectible for the IRS, should you be buying a car? It's an interesting thing. Now, I found it interesting that one of the things the settlement officer did was she made a comment to them that the federal tax lien is part of CNC status. So I don't know that that was the best use of words from her
yeah,
standpoint.
CNC. Well, let me defend this appeals officer, and I didn't know that she had said that. I didn't read that in the case. Not that
Yeah,
it wasn't in English, but the CNC is an administrative decision by the IRS to temporarily hold off, suspend collections on this particular taxpayer for these particular liabilities. Therefore, for that same administrative decision, they can make up their own rules as long as they're not violating a taxpayer right. They can file the lien, because if it's a valid liability that's not being resolved, there's the laws on the IRS's side to have the ability, the authority, the duty to file a notice of federal tax lien. And much like penalty and interest, there are colleagues of ours say, wait a minute, Mark, I got this case CNC'd. How can they still hit this guy with penalty and interest? I just spent 2 months showing ACS that the guy has no ability to pay. Why would they continue penalty and interest? Because it's statutory for the interest, and the guy still hasn't paid. Just because he doesn't have the money to pay doesn't mean that he should have special considerations. So you say, oh, the rich guy should pay, but the poor guy shouldn't pay. Where's the threshold? Where's the thing? Where's the ability to turn that thing around into logical?
one takeaway I think from here is, if this wasn't a pro se case, is this something, and to relate this back to our practice, when you're discussing settlement options with a taxpayer, should the possibility of a federal tax lien almost always come up?
Yes. So when
Right.
you're negotiating with for fees with the taxpayer, and you're going through what possible resolutions are, as a practice note, you should always, a lien, I say it all the time, a lien can happen at any time. I can be the best representative in the world. Everything can be going great. You wanted a hardship. I got you a hardship. I'm telling you, especially when people want it. When people actually, when I'm interviewing a potential client, and they're focusing on the federal tax lien, on it being released and the problems it's causing, I make sure that I turn that back around and say, listen, our goal here in this case is going to be to get the lien released. But in general, unless you full pay it, or we have a successful offer and compromise, which is going to be at least a year from now, potential client, this lien stays on there. Do not misinterpret. That's why it kind of drives me nuts if I ever have a client over the last 25 years doing this that says, Mark told me X. Yesterday I spent an hour and 15 minutes with a client and telling them everything they needed to do. And I had a partner at one point who said, I can't sit through your presentations, Mark. You tell them everything that they need to do. Why do they need us? And I said, I can't sit through your presentations because all you do is say, give me $15,000 and we can help you. And then you see, still gets the bigger retainer, got the bigger retainer. So the moral of the story is, absolutely inform your clients, whether it's in writing. What's the worst the worst that can happen if you told them in writing? The lien, I cannot guarantee a release of this federal tax lien, and/or a federal tax lien can be filed at any time. Especially if they want, I had a case, a guy who's focused on the lien, it's kind of a whiner, let's put it that way. And I said, listen, even if we do this offer and compromise in the next 3 weeks, and we got it in within 4 weeks, the first letter you get from an offer in compromise that says, hey, we're processing your offer, the paragraph after that is, we're going to make a lien determination. So that 8 years, 7 years, that letter's been in circulation where the IRS is doing a lien determination to see whether now have I had a single offer in compromise, not because I'm a great representative, I am, but it's just because my offer in compromises that I did were not deemed to be fraudulent or not deemed to be abusive in the offer and compromise system. But if I was the 4th time I was submitting an offer on the same guy, I got to tell that guy they're probably going to file a federal tax lien because it seemed a little abusive to me, whether I'd even be doing a 4th offer on a client.
Cool. And at the end of the day, it was deemed that she was not arbitrary, capricious. What do they always say? The exact wording?
Handsome.
No.
With hair.
She was not arbitrary, capricious, or without sound basis in fact or law. In other words, the taxpayer was correctly treated, and the lien was sustained.
Agreed.
Yeah.
And I would have agreed with it too.
Yeah.
Now, this other case that I know you don't have, just briefly, Ogden versus the IRS. I know you don't. Did you have that up at all? What's in the handouts?
I didn't put it up. Because it was kind of, we ended up having enough material out of here. I didn't even bother. We should save that.
Okay, we can save.
You know what? I think we can do one just on innocent spouse with those couple of cases that are out there. Do an hour.
All right.
Put that up. All right.
We'll put this for next time, children. Ladies
Everybody, have a great weekend. Where are you speaking, Mark? Where are you speaking in the next 90 days or so? What places?
Michigan. I'm in Ann Arbor for 2 days, like September 29th, 30th, October 1st, right around there. 2 of those 3 days.
For those 3 days.
I'm doing 2 Northern Ohio, and I was officially invited to do NTPI in Fort Lauderdale. The NTPI is moving out of Orlando temporarily. Something about Democratic convention, or is that? I think that's.
No, that's the Vegas thing. Yeah.
Vegas is Democratic convention kicked us out for 2 years or something, and it is so yeah, that's where I'm going to be lecturing. 2 Ohio's, Northern and New York State Society of Enrolled Agents, the annual convention, and at the annual convention they're going to be having me do a resolution table. So I will be actually not even in class the second day. Thank you.
In other words, pick your brain. There you go. Got it.
Bring any case that you want to New York, to the Catskills, or no, not to the Catskills, to Springs,
Saratoga Springs, yeah.
Saratoga Springs.
I will be in Baton Rouge, Louisiana, the 23rd, 4th, and 5th of this month. 16 fabulous credits of me for Louisiana NATP. October 31st, November 1st is my fall international tax program. I have 2 tracks of material, lots of great speakers.
Is that in New York?
That's in Florida, in Orlando, Florida.
Okay.
Yeah. I thought I started that I would be in Orlando. And then in November, I will be November 13th with New Jersey Society of Enrolled Agents, November 15th with Missouri Society of Enrolled Agents, and then I am magically going to fly overnight, and I will be at the Latino Tax Pro Regional Conference in Miami on November 16th. That's going to be a rough couple of days.
I'm close.
October 26th, I'll be in Rutherford, New Jersey, also speaking at the Latino Regional Tax Conference. So we're around. We also have weekly webinars every Friday scheduled, all sorts of neat stuff. Speaking of October, we do have our good friends this October. I have Angela Parker Raddick, and Ellie Nava-Jones doing Ohio local tax returns for the non-Ohio tax pro. So that should be pretty interesting. Hopefully we see you all next week.
Bye.
Bye.
Ciao. See ya. We're not done yet.